to start off, so you've been representing her since the appellate process started, right?
Yeah. So I think that she and I went back and looked. I think that it's been since 2022. She had filed her motion on her own, and then she retained me to do the hearing. So, which is always kind of like a double-edged sword, but I never really know what I'm getting into, and I never know like if it's going to be a good outcome. But I've also won cases where the clients have actually done the motions themselves and they hire me afterwards. So I don't ever like prejudge. And I had no idea who Mary was. No idea.
So tell me, how did her first appeal go?
So, okay, so the way that the appellate process works is she goes to trial, she does a first direct appeal, and that's where you basically like challenge the decisions that were made by like the trial court. I did not represent her on that appeal. Um, and honestly, I don't really do many of those now because it's just you're kind of confined to the issues that the previous lawyer raised, which I sometimes get frustrated with because they don't always raise them correctly or they don't raise enough. So she then, the next step would normally be to do what's called a 3850, which is a motion where you basically allege that your attorney was ineffective. And she actually, with the help of, I think, somebody else in her facility, put together the motion herself. And she filed that with, I think she had numerous grounds. And then she was granted a hearing in Escambia County, and that's when she actually hired me. And I was at my previous firm, O'Brien Hatfield Reese, and my old associate and I actually flew up to Pensacola. We met with Mary. We'd only been on her case for I want to say like 6 months by the time we actually went to court. And we when we finally met with her, I'm not gonna lie, up until the point that I saw her face to face, I had done my own research at that point, and I kind of questioned what I'd gotten myself into. And then when I met with her, I instantly knew that what she had put in there was accurate, if you will, just because what's on the internet and what you see in the media was so inconsistent with what I read. I was like, there's just no way. And then when she described it to me in person, I literally had to like figure out a way to not cry in court just because she got into so much detail. So that's where my representation started, and it hasn't actually ended yet because we lost our motion. She lost the motion after the hearing. The judge entered a really long order, and then we actually put together a motion for a rehearing. Honestly, because I felt like the findings that were made were just not accurate based on what the testimony was. Um, and that's still pending. It's been pending for way too long. And I imagine that we will have a ruling soon. And then after that, though, assuming that it stays the same, because I have only had one judge ever go back on their own order because it's awkward for them to then say, "Oh, I changed my mind."
Hmm.
So I only kind of do it now to preserve the issues that we have for the appeal. So then after this, though, if it stays denied, then we will actually appeal to the first DCA, and I will stay on as her lawyer for that. So
So do you have any idea when you may finally get this second hearing? Because you said she was granted the second hearing, but it just hasn't ever been scheduled. Or did she tell me that?
she might have told you that. So that I mean, that's obviously what the goal is. So we did what's called like a motion for rehearing. It doesn't necessarily mean that we're asking for a second hearing. We're actually asking for her to get a whole new trial in that motion. And the reason behind that is that the evidence that came out at the evidentiary hearing that we had. So evidentiary hearings are weird. They're like little mini trials that people don't really understand the level of work that it takes and puts into it. So we, as defense attorneys, we're normally on the defense, obviously. We don't go first at a trial. The state has the burden to prove. We don't have to do anything. At these kinds of hearings, it's the opposite. So the last 2 days I've been in court, I'm putting on witnesses. I did the same for Mary. We interview, she had this expert that had examined her. We had reports that we had to introduce. We had Mary tell her whole story. It took over half a day for us to present everything. And so we're basically saying in our motion for rehearing is based on what's already out there now, you just made the wrong decision. The facts that are already in evidence now show that she should get a whole new trial because if she went to trial again and she were able to present the issues that her lawyer didn't do and she had an effective lawyer, then the outcome of the case would be different. And that's what we basically argued at the hearing based on her testimony and the expert. Those were like the main two things that we really, really, really challenged that her lawyer, in my opinion, really messed up on. So.
And do they have Did the judges have any sort of deadline to give you that answer by? Like you said, it's been over 2 years since they've done that.
So there's no really hard deadline, or there really wasn't when we filed this. Now the courts in Florida have actually put into effect an administrative rule essentially that says they have it's around 60 days if a motion is taken basically under advisement, if you will. Um, but that was not in place when we did this. So normally what we'll do is we'll file something after the fact, but it just has not been strategically the right time for her, if you will. For whatever reason, Mary's case has picked up a lot of momentum. And I'm happy for that for her because I realized over time that the court of public opinion is sadly one of the, and not, I shouldn't say sadly, but it is definitely more important on some realms. So I believe that if we don't get a decision soon, that within the next month or two, we'll probably file something and try to get the ball rolling. But the judge that we had is no longer in criminal. She's actually in civil, or she's in family. So I don't really know how that's going to work. And that's why I sadly assume that it will become a denial. And I've already told her that, don't lose hope if that's the case. We'll just go to the first district court of appeal and bring the arguments up there, which is why one of the reasons that I did the rehearing was just so I had kind of already, while the issues are fresh in my mind, it just kind of helps make the work easier later on.
Yeah. One of the things that we did as part of this whole thing is obviously we talked to the prosecutor in the case because I wasn't here for her trial, so I wasn't here to
Right.
hear the evidence on both sides and what they had to say. And she was pretty harsh, as you can imagine.
I'm sure.
She still holds true that she believes that Mary and Billy were together, despite what Mary has to say. What are your thoughts on the whole thing?
You know, I I'm very it's kind of an interesting I feel like my viewpoint is interesting because if you would have asked me 10 years ago if I would feel this way, I would probably say there's no way. What? That's crazy. Just because I have such a different viewpoint of I look at context a lot differently now than I would have before. So what I mean by that is I've done so many of these hearings where I'm cross-examining other lawyers and people never want to ask like the why, if you will. And so I always ask my clients that. It's one of the first questions I ask them is how did you get here? I'm never trying to justify it. I'm not trying to make excuses. I just want to know if they know that they did it. If they tell me that they were involved, if they did it, I try to not like mitigate it, but just to explain it to everyone else. And in Mary's situation, the why to me, it does negate a lot of what happened. And I think it just puts things into the perspective. So, from the outside looking in, the story that's out there, and from the prosecutor's point of view, their theory is 100%. If that's all that had happened, I can understand why that storyline could not be broken from her perspective. Because in order to put on a case like this, I think you have to really believe in the case and you have to believe in the story because it is a brutal storyline, and the victims in this case do deserve justice. I went into this understanding that side of it, but also being open-minded to the fact that Mary might be a victim as well. And as I learned her story, and I learned and I did the research on the psychology behind what she had gone through growing up and gone through, and even just like the moments like as she went along, I could never go back now and think that she wasn't a victim as well because her actions, people were like, well, how can, she never went and told anybody. She never tried to get help. She never XYZ, etc. And that's obviously what's out there for the public to see. And the reality is that she has a very justifiable reason for that, psychologically speaking. And I think that, and that's why we focused a lot on what her story was and what the psychiatrist would have said about her PTSD diagnosis, because that was the number one question that people had and they still have. And I tell her, I'm like, I would die on the hill fighting for that girl. And I mean, I don't work for the same firm anymore. I'm on my own and I'm on her case pro bono at this point. So it's one of those things. It's hard to I'm never going to tell somebody that they're entirely wrong, but I think that a part of the story and a part of this is missing. And I do think that it's an injustice to Mary because she is just as much of a victim, except she survived. And that is it's she and I in our conversations, she has literally told me, sometimes I wish I hadn't survived because my survival is literally what has me in prison. And I could have just as easily been one of the women that ended up being killed. And that's a really sad reality and a sad thing to hear. Um, and I think until you actually physically witness her tell her story and you see, her truth and the emotion on her face, there was not a dry eye in our courtroom. I mean, I was biting my lip. I was bleeding and it was hard to watch and then understand that nobody had ever heard that before. So,
And that's what I've started writing. We're breaking it up into three parts, and I've started writing her version of events today and going in, especially the stuff about her kids and the threats that he made to her family. And we're
God,
kind
it
of
gives me goosebumps. I'm like reliving it again. So,
exactly. One of the things I had down for you was um when y'all were talking in her appellate testimony about Mr. Brooks getting her ready for trial. She said that he just never prepared me for trial. I had never been before. I was scared. I had it written down to ask you, is that normal defense attorney behavior to not have your client really involved ahead of trial?
yes and no. I mean, I think it just depends on each attorney, and I think it also depends on the case itself, factually speaking. So, in a case like Mary's, I say this a lot because I'm a firm believer of cases that are high profile require a certain type of attorney to handle them. I'm not saying that Mr. Brooks was not that kind. I think, though, that in order to be an effective representative of somebody who is in a very public case like this, you have to be prepared to not only deal with the publicity, the pressure of that, but also the pressure of not the possibility and the pressure from a possible failure, but in a defense perspective, this is a failure. Her being convicted is a failure. So in these circumstances, that is not a if I was going to put this under the terms of being an effective attorney or what's reasonable under what we are supposed to provide our clients in this situation, I would say this is unreasonable. And I would say that it's not something that any other attorney would probably have done because the level of involvement that she expected to have and then didn't have is a very massive part of the problem because if some attorneys don't really want to know the facts. They don't want to know the full truth beforehand, and they do that for a reason. They don't want to they don't want to pigeonhole themselves, if you will. I had a lawyer today use the phrase less is more sometimes, and that's true. But in a situation like this, there was quite literally no less. Like it was all already out there. It's not like she was possibly not involved. She was literally like she was there. She was involved. There was no doubt about it. So the only question was really the why. And she had already deeply spoken with experts and mental health professionals. They had already discussed, at least to some degree, that that was going to be used, and then it wasn't. So I think the surprise is what ultimately led to the downfall for them. And so that's where I think it just depends on the situation. In this situation, it is definitely unacceptable in my opinion, which is why I think I've gone so hard for her at this point. And they use the word strategic, for strategical reasons. Sometimes we don't want the clients to be actively involved, but it is 100% their right. Lawyers get to have the final say on a lot of things. However, in a case like this, I think it just is slightly different because of how she didn't have like this plausible, there was no deniability. It's not like it was an identity, like it's not like it was an identification issue. Her identity was already out there. So it was more so explaining why she shouldn't be seen as guilty because of becoming involved with all of this. And I think not preparing her was the biggest mistake that he could have done. And she was seriously unprepared, unaware of a lot of things. She didn't see some of the things in her case until we got on her case. It was like crazy. And he was not prepared. And I said this in court. It's in all the pleadings. He was very unprepared on the aspects of the case that people probably really wanted to and deserved to hear about.
And that includes another part I had written down for you. I kind of notated an asterisk in Rachel here, was the blood work didn't come up in the original trial, and that's one of those documents that she tried to show me.
Yeah.
But talk to me a little bit about that and what she has talked about, because she told us that he gave it to her and made her to drink it in this concoction type situation. Prosecutor believes she took it willingly with him. Do you think that should have been shown? And what do you think the truth was in between those two things?
So obviously there's a lot of decisions that get made in terms of, like I said, some attorneys have this idea that they don't have to put on any case whatsoever. But in a situation like this where there are statements that have been made, obviously she gave a very long, lengthy interview right afterwards, which in and of itself was something that was not going to go away. So again, if it's there, you have to explain it. You have to be able to provide information about it. I also am of the school of thought because, of course, and I look at everything in hindsight, which I am literally playing Monday morning quarterback on a regular basis. So I always try to keep that in perspective. But even from the perspective of preparing for a case like this, where she is facing a life sentence and more than a life sentence because of the fact that she has other, potential cases in other states, and the fact that she has so adamantly denied being involved. So I also would look at this as she is a victim. So in order to maintain the level of effectiveness that she deserved, she should be treated as such so that hopefully one day she could be seen as that. I think that a big part of the case is proving that there are falsities in the state's theory. And those falsities in this situation are the the presentation that what she was saying was a lie or that she was pretending to be a victim. And the pretending part honestly gives me the ick. It gives me kind of like it makes me like kind of queasy because I know too much. I know too much now to go back to that side. Um, and I think that presenting stuff like that, so making an argument that she was involved when there's evidence that shows that she was not involved or that she was not a willing participant and she was in a coerced sort of forced situation. That's a very, very big difference. And I think the blood work helps establish that. I think there's a multitude of things that could have been presented that would have established that as well. And I think to not put that stuff out there, it allows a false narrative to be told. And that's not how the system is supposed to work. Everybody has to do a job. And that's what I always say to my clients. And I tell that to other lawyers when they're like, how could you cross-examine me like that? I tell them with all due respect, if we all don't do our jobs, if we all don't put the state of Florida to their burden, then sadly, people go to prison for things that they should not be in prison for.
What is, I know beyond the rehearing, if she were to ever have that conviction set aside or reduced or paroled, what is next for Mary Rice?
So the way that these types of case, the way that the post-conviction works in Florida is we're actually asking for, so for example, if the court were to agree and say that her motion should be granted, she wouldn't just be released. She would actually her case would be reopened. She would be put in the same position that she was before she went to trial, which would be quite literally insane. And at that point, it would be up to the state of Florida would have to decide if they wanted to retry her or not. In a situation like this, depending on which reason the court gave for granting her motion, it could go either way. I have very rarely seen cases not be retried in those situations unless they offer a deal that is so good on paper. And to be candid with you, I think that at this point, Mary's done so much time and that she wants to move on with her life that she would be willing to take possibly a conviction in order to move on from this. The problem with this as well, though, is that I don't think that she necessarily could just move on. I think that she has the potential to deal with factually similar situations in Alabama. And I don't know enough about that. Law is different everywhere. So they make us take which is funny because people are taking the Florida bar exam here in Tampa today. And I don't know necessarily what the charges would be. I have no idea if they would be trying to prosecute. Because again, I think depending on what would happen in Florida, I think would definitely have some weight in the other decision making. Um, and if I was a victim's family, I would be slightly upset. But at the same time, the thing I always try to remind everyone is that wouldn't you be more upset if the wrong person was in prison? Isn't that what you would want for your daughter, your wife, the mother of your children, that sort of a situation. So I just try to remind, I remind myself of that quite often. But so I'm not sure what's next for Mary. In a perfect world, she would either get a reduced sentence and be released or be released outright. And she could try to help people. She spent so much time in prison actively fighting for other women and helping women that she's met fight their cases. And she and I always talk, I'm like, but are you helping the right ones? I'm like, do you have the ability to kind of weed out the crazies, weed out the ones that are telling you that they're innocent? And she's like, well, I don't really look at it like that. She's like, I do. I have gotten good at that. I don't just believe what they say. She's like, but at the end of the day, it's a legal thing. It's not really about whether they're innocent or not. I want to make sure that they have gotten the legal process that they're entitled to. And I kind of laughed because I was like, that's what I tell people when people ask me, how can I represent someone that's in prison? So I think that if everything could work out in the best way for her, I think that she would have a bright future. And I think that this has provided her with insight that you don't get any other way. And as damaging as it's been, as much loss as she's had, I think that she's more focused on trying to make it into a positive situation, which I think speaks for itself in terms of if she was this terrible person who was literally one of the like, what is it, like they say like 10% of serial killers are women. If she was this terrible person, I don't think that this would be her mindset. And I don't think this would be the track of her future, which is she talks to me about this every time we talk. Just how she just wants to help people. She just wants to make sure this doesn't happen to anybody else. She's like, I have to believe that this is why I'm here. And this is why it's taking so long is because somebody needs my help and I just haven't met them yet. And I'm just like, so
Oh, it
I know.
it it's tough. And I, side note, I laugh when you say all the law is different everywhere. My husband's in a cop in 3 different states, so I get it. And then
Literally, I'm like, I don't want to do the bar exam ever again.
my uncle was he was a prosecutor and a defense attorney up in Ohio. And so every time I ask him about cases, he's like, Samantha, the law is so different in every state, so I can't tell
I
you.
know.
So it's funny you say that because I've
I don't even know like I don't like I've just like totally shut that part out. I literally was like, wait, what state is it again? When she was gonna meet with you guys. Because I just didn't, I was like, I don't even know because I just so it was like tunnel vision because I had to be because there's just so much information. Like her case is just, and I mean, I just can't imagine. I just can't.
do you believe they were together?
No, I don't. And the reason I say that, and I've asked her to her face, because I honestly, not even that I would change the way that I represent her. I'm nosy. I wanted to know. I was like, give me the gossip. I was like, because I need to believe her. I need to believe my clients, and I need to be able to trust that what they're saying in the other areas is legitimate. And I don't have a ton of female clients. I don't. And so I have actually been able to, the few that I've had, and ironically, Mary knows most of them because they don't have that many prisons here. But one of my other clients actually referred Mary to me. And I can normally tell based on their answers to other questions that are about non-legal things if they're telling me the truth, and then it helps me with the legal side. And when she would tell me about Billy Boya, I trusted her. I believed what she had to say. I think that she reminds me, no, I should not say this. I was gonna say she reminds me of me. She's just too nice. She's too nice. She thought she was doing a nice thing at first by writing to him, trying to be someone on the outside that could possibly help him get back on the right path. And then, she starts talking to her brother. She learns that he's not, well, I don't think that she ever thought that he was like this perfect angel of a guy, but I don't think that she realized the level of the opposite of that. He was, and I think at that point the damage was already done, and I think that he saw how empathetic and how nice she was, and how, I mean, she didn't have a lot to give, and she still gave it all. If that just kind of puts it into perspective for me, like she's not somebody out there with the world, an endless amount of things to provide to others, even to herself and her kids. And yet she was still trying to offer what little she did have. Um, so I think if they were together romantically, I think that this case would be entirely different from my perspective. I don't think that her story would be, I'm not gonna say it's true, but I don't think that it would be as believable. And I say believable because I do believe that what she says is the truth. And the people that my old associate would always kind of put me back on reality because sometimes in the beginning of my practice, I was very naive and I would just romanticize it, if you will. And she'd be like, Rachel, she would bring me back to earth. This case, we sat in the airport after our hearing and we both were just like silent. And she looked over at me and she goes, no romanticizing here. She's like, that girl, she's like, I was crying. So,
Is there anything else as we go through this? We're going to go through everything that she had to say. How we're splitting it up is Mary's version of events and what the prosecutor has to say about her version of events, because we can't let it be
of
one-sided,
course,
unfortunately.
of
Um,
course.
and then the middle one is going to be what her grounds are for appeal and what she's actively doing for appeal. And then the third piece is actually, you mentioned a lot of it, and I'm so glad you did, is what she's trying to do for herself and for others. And so that's what the entire third piece is about. Knowing that, is there anything that we didn't talk about that you want to mention?
Hmm. Oh, shoot. I was just thinking about something that she said. Something she said in her interview with you. I remember I was watching and I was like, oh, girl, why'd you say that? It was like, oh, you know what? No.
Was it towards the end? Was it
Oh, shoot.
um
Oh, I don't think this is like, I mean, this might not be even be, you can just throw this away, but you guys asked her a question about making amends to the victims.
oh, yes.
And so my paralegal, who loves Mary and talks to her all the time, but she and I were like listening to it and watching at the same time, and she was like, amends? How could she make amends? She's a victim herself. And I was like, yeah, I don't think she can say that though. Um, I don't think there's anything I would say, honestly, anything else. I don't know. I mean, I could talk for days about that girl.